Hello. Thank you for taking the time to visit the Jones Health Law YouTube page. My name is Jamaal Jones, and I'm the principal attorney for Jones Health Law. I specialize in healthcare law and business law, providing various different types of legal services to healthcare providers, healthcare facilities, and healthcare entrepreneurs. Today, I would like to discuss some of the keys to successfully operating or structuring a multidisciplinary medical practice within Florida, the state of Florida. Throughout Florida, a healthy number of licensed healthcare practitioners and healthcare entrepreneurs are joining or investing in multidisciplinary practices for numerous reasons. The primary reason for their foray into this modern approach to the delivery of medicine is usually due to the rising costs of administering treatment to their patients. They are attracted to the idea of increasing revenue, minimizing administrative duties, and partnering with like-minded individuals that may help them to grow their individual practice. However, there are several business and legal challenges that members of multidisciplinary practices must consider prior to participating in a practice. But let's take a step back and ask, well, what is a multidisciplinary practice? A multidisciplinary practice is a clinic established for the delivery of healthcare services through the creation of a network of healthcare practitioners licensed in the state of Florida to provide treatment in various specialties and practice areas. A multidisciplinary practice may be comprised of two or more types of specialties and/or medical services that range from family medicine, chiropractic services, pain management, podiatry, etc. Practitioners may include primary care physicians, psychiatrists, physical therapists, and the list goes on. For example, it's common to see an MD, DC, or a DC, DO practice, or even an MD, DC, PT practice. Today, many patients are seeking alternative forms of treatment that incorporate traditional practice of medicine along with a more holistic approach. If a provider is able to provide various services under one roof, they in essence create a one-stop shop. This also reduces or eliminates travel time from one office to another. For many patients who have certain disabilities or handicaps or issues with mobility, this is a valuable service to those particular clients. Additionally, practitioners can promptly consult with practitioners within their practice or specialists within their group if they have a specific question regarding their patient's treatment. What type of disciplinary practice should I structure? Practitioners must decide what size they want to join. You can have a small, medium, or large. The sizes vary based on the number of providers in the practice and not necessarily the number of patients within the practice, although typically they go hand in hand. The larger your practice, the more patients you do have. But the focus on the size is based on the number of providers in that practice. Typically, when you join a large practice, there may be a significant loss of control of its operation. Large practices typically have an administrator or a management services organization that runs the practice, which frees up more time for the practitioner to treat patients and thus bill. MSOs shield the practitioner from certain patient and employee issues that can be time-consuming. Some practitioners prefer not to deal with these types of issues, while other practitioners in smaller practices prefer to know and understand every detail of the management and operation of their practice. Depending on the size of your practice and your agreement with other practitioners, you can limit or expand your role to a level that is comfortable to you. Small practices are way more involved in the day-to-day business management of the practice. They only offer one or a few services in addition to primary care. Arguably, smaller practices allow the practitioners to build stronger relationships with their patients, making patients less likely to switch from one practice to the next and they're more likely to receive treatment from another provider within the practice. Now, how should I structure the multidisciplinary practice should be the next question on your mind. Medical board and state and federal healthcare business laws dictate how a practice may choose to structure itself. The relationship between providers may require that practitioners enter into several contracts, including, but not limited to, a management services contract, a premises lease contract, an equipment lease contract, and an employment contract. These contracts must not impede the provider's independent professional medical judgments. One issue that practitioners have to address is how they will receive compensation for the services that they provide to patients within the practice. 9 times out of 10, when a regulator decides that they're going to go after a specific practice, this is the reason why they do so. So I cannot stress the importance of determining a compensation structure that is legally permissible under the various laws that govern your practice. And that is why it's very important to hire an attorney such as myself that specializes in health and business law to help ensure that you will be able to do so adequately. There are several different methods of structuring compensation in a multidisciplinary practice. A practitioner may perform their own billing and receive compensation directly to their individual professional association, while other practices will collect all of the fees and then pay the practitioner a flat fee for services minus administrative costs for managing the practice. Now, these are just 2 different ways, but there's a myriad of different ways that you can receive compensation legally. But again, it varies based on factual scenarios that can change from one practice to the next. Now, delving into those legal considerations a little deeper, there's several legal considerations that arise when establishing a multidisciplinary practice. Practices must act within accordance of the applicable federal and Florida law. Your attorney must examine Stark and anti-kickback issues, fee splitting issues, employee versus independent contractor issues, and the corporate practice of medicine issues, among other legal issues. Recently, regulators from federal and state agencies have been cracking down on multidisciplinary practices for a range of violations. Many violations are due to Stark and anti-kickback violations or poor supervision. Under Stark law, a practitioner may not refer patients to an entity for the provision of designated health services if the practitioner has a financial interest in that entity. A financial interest arises if the practitioner has an ownership interest in or an employment relationship with the entity. If such a relationship exists, the practitioner who refers the patient for treatment to another practitioner within this multidisciplinary practice may be making an impermissible referral unless an exception exists. One of the most commonly used exceptions is the group practice exception. A group practice is comprised of 2 or more physicians organized for the purpose of providing medical services to a group of patients. Members of the group practice are required to cumulatively provide 75% of their services through the group practice. This means that one practitioner can spend 60% of his time at the practice and 40% somewhere else, so long as the other practitioner spends 90% of his time at that practice and 10% somewhere else. So it's simple math. You want it to add up to 150 in terms of percentage of time. You divide that number by the number of practitioners. In this example, there are 2 practitioners, so you divide it by 2. You get 75. 170 divided by 2 is 75%. Now, kickbacks and fee splitting issues may arise if a multidisciplinary practice doesn't have a carefully crafted compensation structure between the practice and its practitioners, as I alluded to earlier. Illegal kickbacks are considered by regulators to be fraudulent and abusive activity, which can result in severe fines and penalties and imprisonment for practitioners. Multidisciplinary practices must not give the appearance that its practitioners are being paid in exchange for referring patients to other members of the practice, which is an illegal kickback. In other words, practitioners can't receive varied compensation based upon the volume of patients the practitioners refer to each other. Practitioners must be paid only the fair market value for the services that they provide, minus any administrative service fees, and those fees have to be for fair market value. Fee splitting issues may occur when members of a multidisciplinary practice split or divide a fee amongst each other. Regulators also have issues with how you hold your practice out to the world. The name of the multidisciplinary practice should clearly state the services provided by the practice. It's important to consider all of the factors before making the decision to join or open a multidisciplinary practice. Practitioners should take into account their size, location, patient mix, current financial situation, and future outlook, as well as malpractice liability, licensing and scope of practice, to name a few. Prior to taking any action, you should consult with a healthcare attorney who has experience in dealing with the nuances of structuring and organizing a practice that operates within the confines of the applicable laws, board rules, and any existing hospital privilege contracts. Failure to comply with the laws could result in the suspension or revocation of your license to practice and subject you to significant civil and criminal fines and potentially imprisonment. Now, before I end the video, I would just like to leave you with a few final tips. Practitioners wishing to establish a multidisciplinary practice should initially consider hiring a provider part-time or as an independent contractor until you have determined whether the new practice area or specialty can sustain itself based upon customer or patient demand. You should also implement complementary services that will require minimal additional financial expenditures. Meaning, if you have equipment, you don't want to necessarily have to go out there and lease or purchase additional equipment, because that can be a huge financial expense. You want to bring another specialty into the fold that won't require you to go out there and acquire additional technology for purposes of providing treatment to patients, unless that provider is bringing their own equipment and technology with them. Then that's fine, so long as your leased area, your office, can provide can adequately accommodate that equipment. Now, you also want to thoroughly vet your potential colleague for her moral character and reputation. Check her DEA number and state board history, her past and present malpractice suits that they may or may not be involved in, and where they hold hospital privileges. Practitioners should contact or conduct due diligence of the practice to see if there are any red flags that you should be aware of. And finally, you should review the contract and make sure that you agree, the contract, and make sure that you agree with all of its terms, including the compensation structure. Again, I'd like to thank you for taking the time to look at this YouTube video. Again, my name is Jamaal Jones. I'm the principal attorney for Jones Health Law. And if you have any questions regarding this video and the topic of this video, or any other healthcare or business related legal services that I might be able to help you with, please contact me. There are several different ways that you can do so. You can call me at 305-877-5054, which is our office number. You can email me at jrj@joneshealthlaw.com, or you can visit our website at www.joneshealthlaw.com. Thank you again for taking the time to look at our video, and I look forward to seeing or speaking with you soon.